Good day, ladies and gentlemen. This is Dr. Frel, your professor.
Hello class, good morning. Our topic for today is on the termination of employment. We have two objectives for this topic. First is to assess the different causes of termination of employment, and the second is to compare and contrast the just causes and authorized causes as type of termination of employment. So for the termination of employment, what are the grounds that may result for an employee to be terminated from work? When we say grounds, these are the reasons that justify the termination for a certain cause. So regarding this issue, class, what are the primary purpose under the labor code or under the Constitution? The Constitution provides security of tenure while it recognizes the employer's right to manage his or her business. However, under the labor code, in case of regular employees, Article 293 provides the just cause of termination of employment, and of course with those that is being authorized under this title. Now the question is, for those who are unjustly dismissed employees, they can be reinstated without losing his or her rights or benefits. So let's take these grounds one at a time. The first is with the just cause. So just cause or causes refers to some serious misconduct that are being conducted by the employee while working to the company. Again, class, voluntary acts or just cause are voluntary acts of employees. This includes serious misconduct or willful disobedience by the employee of the law or orders, or his employee or representatives. Second, gross and habitual neglect by the employee of his duties. Also, fraud or willful breach by the employee or for the trust imposed on him by his employer or those in authority, or the commission of crime against to his employer, the employer's family, or of his duly authorized representative. Now, what are serious misconduct? This is being defined as any action bringing the effect of destroying or undermining the relationship of trust and confidence between an employee and an employer. Or in short, these are improper and wrongdoing that are being conducted. So, it must be grave and aggravated in character and not merely trivial or unimportant. It must be in connection with his work, and it must show that the employee has become unfit to continue working for the employer. Now, when do we have willful disobedience? That is when employees' assailed act must have been intentional and is characterized by a wrongful and perverse attitude. So what are the requisites for this? The act must be reasonable and lawful. It should be sufficiently known to the employee, and it is in connection with the duties by which the employee has been discharged. Then the third is neglect of duty. When can we consider that it has to be habitual? Okay, habitual neglect implies a repeated failure to perform one's duties for a period of time, meaning the employee's repeated acts of absences without leave and her frequent tardiness reflect her indifferent attitude to and his or her lack of motivation to work. This is an example, class. Now, absence of or failure to exercise slight care or diligence. That's according to Valenzuela versus Caltex Philippines Incorporated in 2010. Or another is abandonment. That is one of the common forms of neglect of duty or failure to work for or failure to report to work, without valid or justifiable reason, or a clear intention to sever employee-employer relations. Then we have this fraud or willful breach of trust. So in this case class, there must be an act, omission, or concealment on the part of the employee, which involves a breach of legal duty, of trust, or confidence justly reposed. And it must be committed against the employer or his or her representative, and must be in connection with the employer's work. So again class, this is a valid reason of dismissing an employee, such as that of theft or falsification of time card or unauthorized use of vehicle. Then another class is a willful breach of trust, which in turn leads to loss of confidence. The rule is that this is ground for dismissal and does not apply to all employees. This only applies in situations where the employee is routinely in charge with the care or custody of the employer's money or property. Example of these employees are cashiers, auditors, or property custodian, or route salesman, and the like. Now, what are the circumstances that provides valid dismissal for reason of loss of trust? One is if the employee concerned must be holding a position of trust. Second is the loss of trust must be based on the willful breach of trust founded on clearly established facts, in that the act accompanied of must be work-related, and it shows that the employee concerned is unfit to continue working for the employer. Then the fifth one is the commission of a crime or an offense. So this is the act of perpetrating an offense, or in short, there are crimes of commission and crimes of omission. So in this case, the offense must have been committed against the person or property of his employer or against any immediate members of his family. And in this case, a conviction is not necessary for this to be a valid ground for the dismissal of the erring employee. Then an addition class are those analogous cases, or such as gross incompetence and inefficiency, violation of company rules and regulation, and conflict of interest. So what is this gross incompetence? This is a behavior in the workplace that is not deliberate or willful, but nevertheless, it has had some serious consequences in the workplace. While conflict of interest occurs when an individual's personal interests or his family, his friends, or financial or social factors could compromise his or her judgment, his decisions or actions in the workplace. So that would be for the just causes. Now we have the authorized causes. These are those that validly justifies the removal of an employee, but nevertheless, these are beyond his or her control. This includes the installation of labor-saving devices or automation. We have redundancy. Then another is the retrenchment to prevent losses in the company. We have closure or cessation of operation of establishment or undertaking, or it might due to some disease or some analogous cases. So this automation is the reduction of the number of workers in the company, which is justified only when there are advanced technologies and machinery for the production. So in this case class, those who are affected, workers who are affected shall be entitled to a separation pay, which are equivalent to at least his 1 month pay, or at least 1 month pay for every year of service. Then the second one is for redundancy. So this exists when a company has more employees than there is work to be done, or it might be called overhiring of workers in order to, or decreased volume of business or dropping. So in this case class, the affected worker shall be entitled to a separation pay that shall be equivalent to 1 month pay or at least 1/2 month pay for every year of service, or a fraction of 6 months shall be considered as 1 whole year. Then the third one is retrenchment. So this is in case of economic loss, no? An employer can likewise validly terminate employee in order to either prevent an impending loss, or it might be due to the poor financial returns or cut down on the cost of operations in terms of salaries and wages to prevent bankruptcy of the company. So in that case class, the employer must serve a written notice both to the employees and the dole for at least one. So again class, please remember that retrenchment is a form of dismissal due to no fault of the employee. It is a process, no, whereby the employer reviews its business needs in order to increase profits or limit losses, no, which leads to reducing its employees. So again, class separation pay for retrenchment to prevent losses or in cases of closures or cessation of operations. The affected worker shall be entitled to a separation pay that shall be equivalent to 1 month pay or at least half month pay for every year of service, or and a fraction of 6 months shall be considered as 1 whole year. Okay? So as an example class, you can review the case between Composite Enterprises versus Emilio M. Aparuzo and Jovi Kindipan on this case of retrenchment. Then you will find there the arguments of the petitioner, that of the respondents, then the decision of, or the arguments of the labor arbiter, and the decision of the Court of Appeals. Then we have the fourth one as to closure or cessation of operation. So closure or cessation of business is the complete or partial cessation of the operations and or shutdown of the establishment of the employer. So this is being carried out to either stave off the financial ruin or to promote the business interest of the employer. So this closure of business can be done by the employer whether in the presence or in the absence of business losses. Now, if the case is a change of ownership, no, so purchaser has no legal obligation to absorb his new undertaking the employees of the seller unless he agrees to an agreement to absorb. So in this case class, you can review the cases between Zulig Freight and Cargo Systems versus NLRC and San Miguel as to closure of establishment, so that you can have be made aware of the facts regarding their claims, the issues, and the rulings of the court after their claims. Then of course we have in the case of decease by the employee, no? So this is where the continued employment of a sick employee is prohibited by law or is prejudicial to his health as well as to the health of his employee, as well as to the health of his employer or his co-workers. So he may be terminated if his ailment is certified by a competent authority like that of a physician or a public health officer. So as an example class, you may check the case between Eleazar S. Padillo versus Rural Bank of Nabunturan Incorporated and Mark S. Oropeza regarding disease in retirement, for you to find out some of the facts or their claims plus the rulings of the court regarding their claims. Okay class, so that would be all for the topic. And for your activity, select one of the cases enumerated on the slide and identify the facts, the issues, and the rulings of the court regarding the case. Please submit your output in the Google Classroom. Again, thank you for watching. See you in our next video.